Good morning. Welcome. We are very happy that all of you are here today, September 21st, for the first Broadband Breakfast Club of our new season, 2010-2011. This is the third year that we've been doing the Broadband Breakfast Club, and we're happy for the great turnout today. My name is Drew Clark. I'm the chairman and publisher of BroadbandBreakfast.com. We're a news and events company focusing on the National Broadband Plan, broadband stimulus, intellectual property, and other issues pertaining to high-speed internet connectivity and the issues that arise. We have a really great panel today. This is really a case of the expanding panel because we had 3 panelists until the weekend, and we're very happy for the last-minute additions that really round out and help make sure we'll cover all bases possible for this topic. We've got a scholar, a think tank person, a advocacy organization, 2 carrier representatives, and a technology industry official. So our moderator, whom I'll introduce in just a moment, will introduce them. But our topic, of course, is Title I, Title II, what direction for broadband reclassification. Before proceeding, I'd like to give a special recognition to our sponsors. We appreciate them, without whom the Broadband Breakfast Club would not be possible. They are the Telecommunications Industry Association, International Broadband Electric Communications, Inc., National Cable and Telecommunications Association, and we're happy to welcome our newest sponsor, US Telecom. Please join me in thanking our sponsors. Also, I want to highlight for those of you in the audience, we do have a survey. We encourage you to fill this out at your convenience. And also, our upcoming schedule is included at the table. So without any further ado, I'd like to introduce our moderator. Kim Hart is a reporter for Politico, which is really eating everyone's lunch in the journalism business. I'll have you know. I know on good authority that lots and lots of publications are rechanging their business model to deal with Politico. She has previously covered technology as a reporter and columnist for The Hill and for the Washington Post. She has journalism degrees from the University of Florida and the University of Maryland, and has written for the Baltimore Sun, AJR, and several newspapers in her home state of Florida. Please join me in welcoming Kim Hart.
Hi, everyone. Well, as many of you know, I write the morning tech newsletter that goes out at 5 a.m., so this is like afternoon for me. I have had like 7 cups of coffee already, so if I get really jittery, you'll know why. The issue that we're talking today needs very little introduction, especially for this crowd, and neither do these guys who know this issue so well, and all of you know very well from other engagements like this and just talking about these issues around town. I'll introduce them real quickly, and then we'll jump right in. First, we have Lawrence Buak. He is from the Phoenix Center for Advanced Legal and Economic Public Policy Studies. Next to him, we've got Harold Feld, who is Legal Director for Public Knowledge. Jerry Duffy, who is Legislative and Regulatory Counsel for Western Telecom Alliance. We've got Kathy Sloan next to him, who is Vice President of Government Relations for the Computer and Communications Industry Association. And we've got John Mayo, who's Professor of Economics for Business and Public Policy at Georgetown for the McDonough School of Business. And last but not least, we have Link Hoang, who is, where's your title, Link? Oh, here we go, Vice President of Internet and Technology Issues for Verizon. So like I said, I won't spend much time setting up the issue. Everyone knows where we are, and well, problem is where we're going is, I guess, what we want to know. Do each of you want to just kind of give a 2-minute overview of kind of where you see the next step going for reclassification? Is it even going in that direction? Anyone want to kind of kick it off? Sure.
Never failing to dive in here. The answer is beats the hell out of me. At this point, there are so many different aspects of this in play and so many contingencies and so many rumors flying around on a regular basis. I will say that my impression is that everybody is sick of this issue, and that everybody would really like to find some kind of solution, at least in the kind of broad answer sense. I mean, everybody is, no issue in telecommunications ever goes away. I started MAP working on cable ownership, and I left MAP 10 years later working on cable ownership. So, nothing ever really vanishes, but the hope has been, I think, for everybody that there would be something that it would at least settle the basic broad framework. And I think everybody who has been involved in the policy space has been actively trying to reach that result. I think that the problem is that there are just fundamental differences. And at some point, the people who have the authority to make the key decisions, whether that's going to be members of Congress or whether that's at the FCC, have to step up and say, okay, we've heard from everybody, and now this is what we're going to put out there, and make some cuts along those issues which people are just not able to find any common ground or resolution about. My hope is that we will see something like that before the end of the year, one way or the other. But at this point, I would hesitate to make any kind of guess.
Great. Link?
So I wanted to make one caveat. I mentioned this to Drew. I have to leave at 20 after, so if Harold tries to zing me, I can always leave before he puts it on me and be escaped. But on the question of where it goes, I think Harold's right. It's not hard to see at this point. I am encouraged that the House Energy and Commerce Committee is actually engaging in discussions with a lot of players. I think that's very helpful. Our view has been that the Congress really needs to step in here and set the framework for what happens in broadband policy. So in that sense, it's good. And then, of course, Verizon and Google tried to offer a proposal that did try to address some of the issues, and I think actually did go some way towards where some of the advocates had said they wanted to see policy go. For example, we did develop a non-discrimination principle for broadband internet access as part of our proposal, and we had a very specific and I think thoughtful, in our view anyway, approach to how it would be enforced on a case-by-case basis by the FCC. So we gave, again, that's another point that people wanted to address, was what's the specific authority for the FCC, and the proposal tries to do that too. So at least in my view, we've tried to go some way towards coming up with a policy framework that can address some of the concerns people have. I mean, obviously people didn't agree with all of it, but I'm hoping that and I think it actually has stimulated discussions that have begun to move in the direction of some of the issues that we addressed in the policy. For example, the FCC in their further NPRM did list 5 areas where they thought there was general consensus, and they included the idea that case-by-case enforcement seems like an interesting and worthwhile idea.
Kathy?
So I agree with Harold, certainly, that, is this on? Am I good? That not only are people sick of this issue, but it's really sucking all the oxygen out of the room among policymakers on the Hill and at the FCC. It's taking too much time. Maybe not too much, but it's taking so much that we really need to come to a decision point so that the policymakers can move on to other issues. There's no shortage of other issues that are important to these industry sectors that are so important to our economy as a whole. And and in terms of certainty and getting to a decision point, my own experience is that, that finality never comes from Congress in short order. The telephone companies first started in the 1980s lobbying to get rid of the MFJ antitrust consent decree and put in place instead legislation that would give statutory authority over these issues of competition in telecom to the FCC. Well, they started in the 80s and they were successful in 1996. So talk about using up all the available resources. So in any event, the FCC has been working on these issues for 2 or 3 years now and has really well-developed record that they can act on should they choose pretty much any time now.
Yeah, the Western Telecommunications Alliance represents rural telephone companies. They're all, a couple hundred or a couple thousand lines, 5, 20, 40 employees. We don't do a lot of content. The focus to date has been on building out the last mile. We've got some combination of fiber and DSL out to about 90% of the customers in the rural telephone company areas of the country. Unfortunately, that's only about 8% of the population. It's about 30% of the country's area, but it's a small portion of the overall access lines. Our interest, we had a choice years ago. Most rural telephone companies picked Title II regulation. They did that because they needed to recover the cost of building out the last mile and get that through USF as a telecommunications carriers. So we don't have a huge fight in this, the current net neutrality aspects. We had some concern about network management, but we've done fairly well operating under Title II.
John?
So my background is as an economist. I'm not a lawyer. That's my caveat. And so I'm a little more removed from this process maybe than some of the folks sitting here are. So they have a comparative advantage in saying where we're going. Let me just draw an observation about perhaps why it's taking as long as it is. And from my perspective, the reason it's taking as long as it is, aside from the normal amount of the fact that there are billions of dollars at stake, that will draw people out and have them fight. Aside from that, what you've got is a legitimate difficulty of a regulatory structure and regulatory language that was put in place fundamentally in the 1930s, at a time when public utility regulation was the norm. And today we have a modern internet society that looks very, very different than that public utility world. And yet you've got an FCC with those same regulatory tools and sort of, as we say in the South, bless their hearts. They can do what they want with those regulatory tools, but they are going to be limited. So there is an additional tension and an additional difficulty associated with who's going to move the ball forward. Is it going to be Congress or is it going to be the regulatory authorities? And you see that playing out. From my perspective, you see that as one of the additional delaying features of getting some resolution.
Larry, anything to add?
Sure. I mean, I think part of the problem why we haven't had resolution to date is that net neutrality means different things to different people. And part of the problem with the debate is that everybody has their own individual conception of what net neutrality means. For some people, net neutrality is a free speech issue. For some people, net neutrality is a media ownership issue. For some people, net neutrality is a price regulation issue. And one of the things, just going back to the original Comcast case, to me, what struck me about that case was the core question in the debate was never asked, which is, was Comcast blocking in some sort of anti-competitive way, or was it blocking managing its traffic so that the needs of the few don't outweigh the needs of the many? And I think we've lost sight of that. Admittedly, the legal framework underlying the overall principles has been difficult at best, and Harold's written a lot about it, I've written a lot about it. But when you came out with the FCC's open internet, NPRM, I guess it was a year ago, October, this was an NPRM which totally ignored all the relevant case law. I mean, it was just shocking. It came up with its new definition of discrimination, which was totally inconsistent with 201 and 202 and 60 years of public utility case law. So it's no surprise why we're in the position, because it's just sort of been this wild discussion without focusing on what are we concerned about and what are we trying to fix. And there, I think, which is why we're sort of in the pickle that we are today.
Great. Link, you mentioned, or I think it was Link who mentioned that the Waxman bill. That's been top of discussion for a lot of people, I know especially reporters, in the past few days. I was wondering if any of you had thoughts or could speak about what that bill and what that process says about how things have perhaps shifted a little bit. And clearly there are the chances of this bill going anywhere, especially with the House looking like they might even adjourn at the end of this week to go back to their districts for elections. It doesn't look like there's a lot of time to find a consensus and to move forward. But I wondered if you could give a sense of, or anyone who wants to talk to this, what does it set the table in a way that's different? Does it put priorities on things that surprised you perhaps? I know it didn't necessarily have concise non-discriminatory language, but did give the FCC authority to enforce the 4 principles for the next 2 years. And so I wondered if if anyone wanted to talk about where the Waxman bill, whether it goes anywhere or not, leaves us. Does that change the situation at all?
Well,
Have I stumped
it's
you?
difficult. Like you said, Kim, it's hard to tell what's going to come out of that process. Like I said earlier, I think it's very positive that they did engage in a discussion with a whole range of stakeholders. I think the dialogue, I don't want to comment on the details because I think that's all in the discussions. But in terms of the fact that they're dialoguing, it's good. And it includes the advocates, it includes the industry. And a lot of the discussions we've had in the past when it came to the Hill tended to be like a hearings kind of format where there's a lot more politicking, frankly, going on and not as much discussing what are the real issues, how do we resolve some of them. And, the industry has really taken this seriously. We have been working for the better part of 5 or 6 months now on creating a broadband internet technology advisory group. We've made a lot of progress. We're trying to ensure that it has advocates as well, but they've got to have an engineering and technology background. It is not a policy-focused organization, but its intent is to try to provide a forum where people can get together, engineers, technologists who understand the internet, broadband networks, and frankly, how content services work and so forth, and discuss things like network congestion issues. A lot of these things tend to become policy issues when in fact many of them are rooted in technology problems on the internet, or how you manage congestion, or how you make sure that video gets through, for example. And I'm hoping, and I'm pretty confident that within a month or two we'll have an announcement about the formation of this group. There was a short announcement made by Dale Hatfield, who's heading it up, a couple of months ago, that we're making progress and that we're planning to continue meeting. But we're doing everything, including what the corporate structure ought to be, what the dues process ought to be for players and so forth. And as I said, we're also trying to make sure there are academics and advocates involved in this process. So I think it could be very helpful to help resolve some of these issues so they don't turn into regulatory disputes.
And then Kathy.
And I would just say a couple of things. One of the problems, as we're seeing here, is that there's a broader question about the legal framework for the FCC to move forward in the National Broadband Plan, which is what the Title I, Title II discussion is about. The question of regulatory classification is neither a question of, I keep hearing this, it's this old antiquated, 1934 Depression era, it's stupid the way Glass-Steagall was stupid because we repealed that and nothing went wrong. But the issues are actually fairly broad and deep. They encompass the universe of Universal Service Fund, privacy, public safety, when the part of the problem is if the insistence is we're going to, as a trade-off for network neutrality, cut off Title II, which has been one of the insistences on the carrier side. The difficulty becomes that you are creating a lot of problems that go beyond whatever you might or might not agree about on network neutrality. I think that, again, Waxman's folks and their staff, I think, have worked tirelessly on this. This is something I think that Chairman Waxman feels, personally very committed to, and thinks that, there ought to be a solution, that people ought to have certainty, that we ought to be able to move forward on this, and that certainly the greatest certainty comes if Congress acts rather than if the FCC acts under the existing act. But at the end of the day, we still think the FCC can and should act. And I'll just add one last point, which is, in 1996, Congress added definitions of things like telecommunications service and went to an awful lot of trouble to make that as neutral as possible with regard to service and technology. The notion that Congress only meant the old public switched network, and that being the voice network, which it actually defines separately in the Act as the public switch telephone network. And that's all that was really meant by Title II, and that's all that should ever be meant by Title II, is simply not accurate. You know, there are certainly things we could do in a statute that was designed to address broadband specifically, but the notion that the statute as written now was not intended to be flexible enough to deal with emerging technologies is, I think, just false.
Kathy?
So 3 points really quickly. First, I certainly agree with Harold on behalf of the industry sectors that are part of the internet ecosystem in software, hardware, applications, online services, et cetera, that the notion of critical telecommunications infrastructure is not antiquated. It's not old-fashioned. We still have telecommunications that everybody critically depends on. Secondly, Link's company's efforts to develop this technical advisory group have been wonderful. Ditto for so many other carrier and non-carrier industry groups. I don't think up until this point the public interest community has been included, or that the FCC has been included. We think they should be, but one little point that really spells it out is Link mentioned dues. Okay, if there are dues at all, even if they're very low dues to belong to this group, what student innovators or entrepreneurs in their garages are going to even have a seat at the table?
That's only for companies, not for advocates and for academics.
Okay, no, but hold on, but we've got a middle category. Innovators and entrepreneurs and startup companies are not either. Okay,
No.
so
You'll see
They might fall
when
through
you
the
see the actual announcement. It is
Okay.
designed to be
We'll wait and
transparent,
see.
as open as possible, and get as many people engaged. That's the objective. Otherwise, it can't work.
Okay.
It
and
has
then-
to be open.
And then the third point is to actually answer Kim's question about the Waxman bill. There is no Waxman bill. There is a draft, a staff draft that's been bounced back and forth among the various groups. And there could be a Waxman bill in these last couple of weeks of Congress, but nothing has been introduced. So, and there are some, not you, but there are other reporters who have kind of jumped the gun.
Harold's right that the act was intended to be flexible and deal with new developments in the industry. And back in 1998, Bill Kennard and the FCC then looked at this issue of how information service, internet, broadband internet access services ought to be categorized. And they decided that it was an information service that included telecommunications. So they did see them as integrated. It wasn't telecommunications services. Those are two different animals under the Telecom Act. But they believed it's a different category. And he specifically found in that report that they didn't want to impose the traditional regulations on these networks because they were new, they were just being deployed. They wanted to see if they could encourage competition. And it worked. We have had a lot of investment in this country. I can tell you on a per capita basis, there's more investment in the United States in broadband than there is in most European countries. We're seeing a lot of investment in LTE technology and the wireless side. So we've got a very vibrant and growing industry that's actually one of the few that's investing a lot. And I think those policies help contribute to that.
John, did you have anything to say? He mentioned investment and what this all means for how much money is going into this industry. Do you have anything to add there?
Sure. One of the features of this debate, the Title I, Title II debate, is that it is very oftentimes mired in a legal discussion that you see sort of percolating out here a little bit. There is, from my perspective, another issue, and it's the one that you just touched on, and that is the larger economic impact in terms of the investment consequences of tightening the regulatory screw and moving back toward a more public utility regulation-oriented model. I think that let me just start with an observation. Markets don't like uncertainty. Markets really don't like uncertainty. We've seen that a lot over the last couple of years. When you think about that notion in the context of imposing Title II regulation, I think almost any dispassionate observer would suggest that that move will create a lot of uncertainty. It creates a lot of legal uncertainty. It creates a lot of uncertainty for the firms themselves. It almost certainly, I think, almost certainly will create a reduced propensity for investment in this country. And one of what I think only can be described as one of the very few bright spots of investment in an otherwise really, really soft economy. Last year, I just looked, the leading carriers invested almost $50 billion with a B, dollars, in renewing and upgrading their infrastructure. And that's in an extraordinarily soft economy. You just don't see those sorts of numbers in other industries. That's a real bright spot. And I think before we move toward a system that tampers with that, we ought to pause a lot. I think the other feature of this that I worry a bit about in terms of investment is that not just the implication on the broader economy, but within this industry itself, there's a legitimate and honest goal that I think everybody across the wide spectrum shares, whether it's folks that are consumer interest folks, public interest folks, the carriers, the regulators, the legislators, and that is that we'd like to get broadband deployed and adopted as rapidly and as quickly and as ubiquitously as we possibly can. My concern is that if you do something in a regulatory context to reduce investment in this industry, harming the quality of that deployment, that it actually creates, instead of a virtual cycle upward on the deployment that's happened over the last 10 years, a vicious cycle of reduced investment, lower quality, lower adoption, and creating exactly the opposite result that you'd like to get.
Okay, and Harold, you had something to add?
Yeah, I mean, this is part of why I'm like, it's time for policymakers to just make a cut. Because all of the stuff we've been saying has basically been repeated by everyone over the last 6 months, year. We've all submitted our studies. I've got my studies that show that network neutrality is critical to maintain investment and that regulation doesn't have impact on carrier investment. They've got their studies that show it would be a catastrophe. I've got my analysts who, when stocks started backing off because people on Wall Street took that stuff seriously about how it was going to be a killer for the carriers, you had a whole bunch of folks come out and say, no, don't pay attention to what we say in Washington. Really, this is still going to be great. And they've got their folks who are saying, this will be awful for the industry, and, nobody will invest in broadband, and 95% of the U.S. will be back on dial-up in 5 years if we go with Title II. I mean, we can all have these same conversations. We have all submitted a fair mountain of evidence at the FCC. Now, some of this, of course, boils down to do you think that unregulated markets are perfect, or do you think that, there's some need for regulatory oversight? Which, again, I know where I come down on that, and that to some degree is an ideological debate, and that's, the political debate that we're having in this country. But we've got all the evidence that has been, put out there on all of the, basic policy points that we're likely to talk about here. It's time. I applaud Waxman for trying to move forward. I think, as a practical matter, it's unlikely to have significant impact. I think if legislative efforts had real legal impact, this town would be very different given the number of bills that are introduced by people, that don't go anywhere. So I think, as a practical matter, it really bounces back to the FCC, and it bounces back to Janikowski's got to make a choice.
Kim, this is the interesting thing. We seem to be talking past each other, even though I think in some ways we're saying not something different than what Harold said. The proposal we worked on with Google says that on broadband internet access connections, there's a rebuttable presumption that prioritization would harm consumers or users. So it already does what they want, a non-discrimination principle. We developed it in that proposal. We also developed an enforcement mechanism that's very straightforward and gives the FCC authority over these broadband internet access services. And they said they wanted that, and that's what we proposed.
Yeah, and at the same time, it also included a couple of showstoppers, like no FCC regulatory authority, which I got to think is crazy, because God knows if anybody had asked you in 1992, do you think that Verizon didn't actually exist then, but do you, the telephone industry that's looking at getting into video, think you're going to need program access rules? You guys would have said, oh no, we're going to be able to purchase whatever programming we wanted. When it moved to, are we going to need rulemaking authority and program access in order to get it, terrestrially distributed? If 1996, I bet you guys would have said, hell no, we don't need to worry about that. The fact is, industries change, and in order to maintain the FCC's flexibility, it needs to have, the ability to step in response to changes in the marketplace that make a big difference with regard to competition. And even if we accept the premise that the telecommunications market, that the broadband market today is competitive, then I would say, at the end of the day, the notion that we could be in a situation where we have critical infrastructure that nearly every consumer in this country ultimately is relying on to some degree, and we have made it impossible for any regulatory agency to step in response to changed circumstances, should, as a matter of prudence, actually worry everyone, even the carriers who think that they will be better off in a regulation-free world.
There's two things that are wrong with that statement, though, Harold. One is that you say that the FCC couldn't step in. We make it clear they can. And second, there's a lot of other mechanisms in the internet today that work to do a lot of things you're talking about. The internet is not the circuit switch telephone network where the telephone companies ran everything. We had all the protocols, we ran the switches. Nobody actually participated in that process because we had all the expertise. There's a lot of people with expertise in this environment. They work in a whole bunch of bodies that have everything to do with maintaining security, to helping develop issues against spam. I mean, there is a lot of mechanisms in the internet that work to encourage collaboration, encourage problem solving. It's not all the government. That was my point.
I agree with you, and I think that's great and wonderful and fantastic. The problem here is, again, not a question of talking past each other. The question is, how do you maintain that environment? And for those of us who believe that part of what keeps that ecosphere going is the fact that there's a little adult supervision out there in the Wild West, it's very troubling to see a proposal, which was in the Google proposal, which says, we're going to give the federal government the exclusive jurisdiction, so we've cut out, the states and anybody else, and then, and in addition to that, we're going to set very narrow parameters on what we would permit the one federal agency that actually will have authority in this area to do. And while I think there ought to be certainly limits on federal authority to provide certainty, at the same time, there needs to be greater flexibility than what was proposed in the Google Verizon framework.
I'm going to let Larry jump in here since he's been waiting.
I was enjoying the show.
Oh, this isn't a show. This is a morning conversation.
There you go. But I think, Lincoln Harold, you can see the issue here. And I think if you sort of view it from a 20,000-foot level, and I go back to my earlier comments for a moment, and that is, what exactly are we trying to accomplish here? And nobody has defined that. And the problem is, I mean, look, I'm in the tank for the FCC. I think there should be an FCC that's there as a cop on the beat. But regulation has costs, regulation has benefits. So you always need to take each individual case and sort of do that cost-benefit analysis. And the problem here, I think, with the overall Title I, Title II debate is, and this comes directly from Chairman Janikowski's own statements on this and Austin Schlick's statements, is that, well, and they admit, well, Title II can stymie investment because it is very heavy-handed. But yet we have this legal risk of Title I. So this notion is, well, allow me to take Title II and I'll forbear all this stuff, and then trust me, I won't do all this heavy-handed regulation. And that's really what I think everybody's really concerned about, because the issue is not, do you try to write a better order so that the court goes, okay, you got it right this time, and I think the commission had it wanted to, could have done that. But it's, trust me, I won't exercise that new authority once I have it. And the problem is that if you just look at what this commission has done, they have no analytical credibility to say, I won't take more than what I'm trying to do here. I mean, the most classic one is, well, we don't want to do price regulation. The Open Internet NPRM says very clearly, thou shalt charge the same price for two completely different services. That is the sine qua non of price regulation. You can't get away from that. Oh, they've said in the Horgan report, we want a price point of $25. Okay, everything else starts to talk about affordability. Oh, we're not going to regulate wireless. Well, what have they done? We've done ETFs. We're still talking about a wireless cardophone. They snuck out a de facto spectrum cap in the Harbinger order. All these things are going on, which makes markets uneasy, going to, I think, John's point of what is the certainty. So I think this whole debate has missed the key point of what are we concerned about? Are we concerned about somebody anti-competitively blocking traffic on the internet? Or are we just going, I don't like the price that you're charging? And those are two very, very different questions.
Kathy, and then I'll let.
So I think the goal has been articulated many times over and over by policymakers at the FCC and advocates as well. And maybe it's because it's so simple and non-technical that it doesn't stick with everybody. And that is simply to maintain the open character of the internet so that all end users, be they large or small, can innovate without permission from the network operators. What we're talking about is maintaining the status quo, and it really doesn't have anything to do with price because price is not regulated now. And why are we concerned that we need to maintain the status quo and it won't maintain itself? Well, because various network operator executives have said that they want to move to a different business model where they can prioritize, where they can sell higher quality of service to higher paying customers. And why is that all a problem? Well, sure, I mean, we have no problem with tiered pricing and bandwidth hogs paying more and that sort of thing. But if it's going to be just selling bandwidth to the highest bidder where there might not be any left for everybody else, that could be a problem. There are also two market realities here, and I'm no economist, but that often get short shrift, and they relate to competition. Really, households and small businesses have many fewer choices than they might for broadband internet access because of two things. The cable TV broadband companies do not compete with each other. They've sliced up and diced up the geographic markets. Likewise, the telephone companies do not compete with each other for wireline internet access. Sure, they do for mobile broadband, but not for wireline. So that's what causes the situation where the typical local market is a duopoly between one cable and one telephone company.
So they compete, right?
So those two compete,
right.
but that's two. As opposed to it could be a whole lot more if they didn't, divide up exclusive geographic territory. Secondly, as The Economist magazine recently pointed out, U.S. broadband operators of both kinds are not required to open their high-speed networks to rivals on a wholesale basis. In other parts of the industrialized world, including Canada and the UK and France, there's all kinds of flavors of unbundling or wholesale interconnection requirements. We don't have that here. Not saying we should, but given that we don't, we need some sort of, adult supervision, as Harold put it.
And Jerry, you had something next.
Yeah, I come late to this debate, and I'm still trying to figure out what net neutrality means. It seems to have lots and lots of different meanings. From a Title II basis, the existing regulation, it is not a horror show, and it is not something that is very detailed. It's very plastic. It's the basic Title II structure is that it requires just and reasonable rates, practices, classifications. It forbids unreasonable discrimination, and it forbids undue preferences. That's proved very workable in the telecommunications industry, and it assumes to be pretty much of what you're talking about here. There's not heavy-duty rate regulation. There hasn't been a heavy-duty rate regulation at the FCC or at most of the states for years. There is no content regulation. On the other side, if you make the FCC the main cop, I've been around the FCC a long time, a Section 208 complaint, you file it, and maybe 2 years later you've heard something. The complaint process works extremely slowly unless you got the attention of the chairman and he pushes it up fast, but there are very few of those. Most complaints languish for years and years and years. You can file them while your kids are in college, in high school, and get paid for more work when they're going to college. It is a very long process.
Yeah, John, and then I'm going to let Link follow up since I know he has to get out of here pretty soon.
Okay, I'll be quick.
No, it's okay.
I certainly applaud your focus on competition. I think that's something that we can all agree upon is something that would be in the benefit of consumers. The question is what do we mean by competition? And the sort of the very, very simple. I've been a student of competition for 30 years. The very simple notion is one of rivalry. And the more intense that rivalry is, the greater one would think the competition is. And certainly while we could do a head count of 1, 2, 3, 4, the number of providers, and that's not without some information content. I will tell you that in this particular instance, from my perspective, what I observe is a massive amount of rivalry between the incumbent telcos and incumbent cable companies that have, over the last several years, been benefiting consumers considerably. Now, do we need adult supervision? Absolutely we do. Should we have, in fact, do we have a number of public agencies already charged under existing statute and existing regulatory authority to protect consumers? Yes, we have the FCC that's charged with protecting the public interest standard. We have the Department of Justice that is empowered to protect consumers from contracts, combinations, or conspiracies in restraint of trade, including territorial dividing up of which sends people to jail if they do that. And the Federal Trade Commission, which also has a public interest standard against unfair methods of competition. So we actually do have some adult supervision in place. You'd like to think that they're awake adults. That would be a really good thing. And I think that if you look at the antitrust authorities and the FCC today, I think no one would say they're asleep at the switch right this minute.
Link, do you want to follow up or?
On the unbundling question, I think again goes back to what the policies are and what our purpose is in those policies. And if you look at the numbers globally, there are very few countries that have head-to-head facilities competition on the level we do. Most countries have very little cable competition. Mostly it's the incumbent telephone company, which is why a lot of them have sharing requirements. If in the United States, and again, going back to the Kennard decision in 1998, one of the reasons he did that, and you can read the decision yourself and find out why he said that, but basically he was saying these are new networks. They're not the old telephone network. They're being deployed now in ways that are going to compete with the telephone company's DSL. I want to see this work out. I want to see if facilities-based competition, in fact, will emerge, and it has emerged. So it's a different market in the United States. Every market's not the same. Second, on the wireless side, it's even more competitive. Not only are there open models, like Clearwire, for example, does not have the same model as some of the other companies where you basically can bring any device you want to on the Clearwire network if you want to compete. But there are also open models in our company. We have the Open Development Initiative now. Why? Because there's a lot of competition in market. We're trying to create new ways to grow value for the consumer. So now you can bring a device to Verizon, essentially 5 weeks test, that's it, just to make sure it connects well to the network, not the old cell phone test. We usually do 12 to 18 month tests on cell phones when we sell them in our stores. This you don't have to do. You bring it in 5 weeks later, you basically can take a device and sell it yourself. And there are a lot of wireless devices that have been approved already to do that. Why are companies doing that? Because it's a very competitive market. You got to find ways to provide value to the consumer. And wireless is beginning to emerge as a broadband alternative for people. The latest Pew study shows that African Americans and Hispanics, for example, are very aggressive and active users of mobile phones for data access. So we're seeing the markets change a lot. I think we're seeing a lot more competition, and it's not as implied by Kathy's remarks.
And I'm going to open it up to questions from the audience now, especially if you have, Link, do you have time for one question from the audience if someone has one for you? Okay. So first of all, does anyone have a question specifically for Link about Verizon, Google, anything?
And yes, we did do a gig test to the home with FiOS, so that's another indicator of competition.
Okay.
I want to ask this question before Link left. By the way, I'm Kerry Hinton with DC Public Service Commission. And this is actually a question I think that some of the other panelists will want to comment on, but the primary discussion point this morning has been on net neutrality and reclassification. Others have suggested, and I think Harold was one of them, that the reclassification proposals could have implications for other elements of the National Broadband Plan, specifically USF reform. And my question to Link and to others is, can the FCC go forward with reclassifying broadband as Title I, yet still have USF reform to establish a connectivity, I should say Connect America Fund and a mobility fund that will provide funds to broadband service providers for building out their infrastructure to provide services that aren't telecommunications services?
So is your question, because of the court decision, does the FCC not have authority to implement parts of the National Broadband Plan?
No, no, the question is if they do reclassification as Title I, will they still be able to go through the USF reforms that have been proposed in the National Broadband Plan and that others have been advocating regarding establishing the Connect America Fund, establishing the Mobility Fund to provide funding for broadband service providers such as Verizon, both on a landline and wireless basis, to be able to provide broadband services?
I'm actually, Kerry, I'm not the expert on that. I know that our filings we've been making about the issue of whether or not the court decision had an impact on the USF or wireless, for example, and FCC oversight of those industries, we said no, that in fact they have authority to reform USF and they have authority to oversee the wireless industry and the spectrum that they oversee, that they have authority to do that. So I don't believe, we believe that changes.
I think it's actually slightly technically correct. I think the issue is that the National Broadband Plan has recommended, I agree with this, rather than subsidize switch telephone lines, subsidize broadband, you get a lot more bang for the buck. The issue is that if it's, because the statute says you've got to subsidize a line as opposed to broadband, if you don't reclassify it as broadband as a telecommunication service, therefore you cannot use subsidized broadband, you're stuck subsidizing lines. Without commenting on, I mean, I've seen arguments back and forth. I think it's the right thing to do to subsidize broadband. It may need a legislative fix. Maybe the commission can squeeze it out. We're not sure.
Sorry, you go.
Yeah, the act is inconsistent. Section 254B talks about advanced services in places, and it gives the FCC the right to increase the number of services that are supported. It's always thought the FCC could support broadband services, but then there are questions about the people who receive the USF are eligible telecommunications carriers. And so there's a couple of things that they've got to work out. As a whole, the industry is working toward universal service reform with the assumption that broadband will be supported explicitly. What happens with rural telephone companies get USF because the commission has long allowed us to build networks that had multiple uses, and as long as one of the uses was voice telecommunications, you get support for the line going out to the customer, even though the line was also DSL and broadband capable.
And you voluntarily operate under Title II.
Title II, yeah.
So that's what it is. I mean, what the problem is, we have and Harold can get into the legal technicalities, but we have a void at the FCC right now after Comcast, where the public interest, as John so rightly pointed out, in broadband is unprotected because broadband was classified as a deregulated information service, whether we're talking for net neutrality or for universal service funding or for privacy issues or for any number of things. So that the peril to not reclassifying and not relying on Title II goes well beyond net neutrality. Harold, you have something?
Yeah, let me add two things. One USF specific and one that gets to something of the broader point, which is the problem for USF is that the Comcast decision has made everything a dice roll, and you can't even talk about things intelligently. I had a meeting with some FCC staff a month and a half ago about USF, and we started the conversation with, we're not going to talk about authority. We're just going to talk about, what you want to do with, USF fund and how you think we ought to reform the high cost fund. I'm like, okay, I can, that's fine. So I started to talk about, our proposals, which are captured in our ex parte. And they said, well, how would you do that? And I looked at them and just said, it depends on what your theory is of legal authority. Because much as, with all due deference to people who think this is an economics problem and all due deference to people who think this is an engineering problem, they're right. But at the end of the day, there also has to be some kind of legal foundation on which any of these things proceed. Which is the other point that I would like to raise, which is there's another recommendation in the National Broadband Plan, which was to adopt certain sorts of public safety reporting requirements that are right now used on the phone network, particularly with regard to outages. We have here what everybody acknowledges critical infrastructure. We have no idea how reliable it is. Industry folks do voluntary reports. There's a lot of discussion, but we don't have a lot of certainty around it. So the FCC put out a public notice, said, should we adopt the same reporting requirements? As you might expect, the state PUCs and Neshoka and others said, oh yes. The carriers mostly said that would be such a bad idea and it would be expensive and do no good. But you had a couple of carriers who stepped up and said, you don't have authority to do that. This is an information service, not a telecommunications service. Tell us what your authority is to make us report purely broadband outages. And my analysis is they're right. Under the Comcast case, it is very hard to find what the FCC's authority is to require mandatory reporting of broadband network outages. Now, maybe we don't care. But it is emblematic to me of one of the problems that is going on here is that the myopic focus on network neutrality and the fact that everybody drags this back to network neutrality, which has become the black hole of telecommunications policy, is blinding us to the fact that if we are going to proceed, particularly if there is a legislative proposal that will prohibit Title II, that will have profound consequences. The things in Title II that we have did not arrive there merely as a function of it being drafted in 1934, which it was not. It's been evolving over time. They have been placed there because there were social needs. Now, maybe in some cases, those needs have gone away, and that's why the FCC has forbearance. But for a lot of these things with regard to stability, public safety, reliability, and even, dare I say it, affordability, there is still great need, and we either have to reinvent all of this all over again, or we can figure out how to use the tools that Congress has already provided.
Larry?
Yeah, just a couple of quick points. And this is all, really important stuff. First off, one quick issue with Harold is that depending on what the statute is, one can still make an ancillary jurisdiction argument. Comcast did not say the FCC lacks authority. The Comcast court said the FCC wrote a lousy order and didn't hook what it wanted to do in that case to a specific statute. So each case is going to be different whether you want to do that. My other point is that there is a flip side actually to all this classification stuff. As we move, if everything's going to from an information service to a telecommunication service, you are now opening up, for example, all the carriers, broadband service providers, open to huge local taxes, right? Because states tax telecommunication services, they don't tax internet services. So that's could be a huge tax impact. You're seeing that now with the cable companies and pole attachments, which is a huge issue. Is it, do you get the cable rate, do you get the CLEC rate, do you get the ILEC rate? So all these things are now playing, which is why this thing is such a mess.
Other questions? Really?
Everybody is really
Since there's a void here, I hate voids. The FCC has issued a second notice of inquiry, I guess, asking for further comment on two specific issues regarding the application of reclassification to wireless services, and also secondly to specialized services. Actually, they talked about specialized services first, and they talked about wireless services. And they did kind of as best as I can ferret out through that notice, did a rather minimal definition of what specialized services are. In fact, they basically said specialized services are not managed services. And they try to draw an analogy that specialized services are not managed services because managed services are generally understood in the industry as being for
Enterprise.
Enterprise customers. Thank you very much, Kathy. I'd be curious as to what your understanding is of what specialized services are and what implications that may have based on that definition.
The reason there's silence is because Link is not here. Specialized services is a catch-all term created by the carriers in which they can put everything that they really want to do in terms of prioritization. The FCC, in its notice that you reference, suggests that really specialized services need to be something really new and different that is not basic internet access. For example, some telemedicine kind of function or whatever. But that's not what the carriers have in mind. And I can't speak for exactly what they have in mind, but that's why we have this definitional problem.
John?
I'm not an attorney, and again, I'll offer that caveat. So I am not sure that they're asking for an economic opinion on this, but reading between the lines from my perspective on that language, there is an honest tension, and I sort of applaud the commission for seeking additional information on this, that says, on one hand, the fact that you're providing internet access service puts you in a position very naturally, as a matter of just straight up economic efficiency, to be able to offer efficiently other goods and services that you may be the very best provider at, and to be able to satisfy consumers. And that would be a very good thing. It also may mean that if you're doing that, there's the possibility, not by any means the assurance, but the possibility that you could engage in an anti-competitive practice against rivals that are also offering that other service by virtue of the fact that you have that access. So, it's something that's a substantive discussion from an economic perspective. It can be worked out, but I think that's an honest inquiry, and I'll look forward to seeing what people say.
Yeah, I agree it was an honest inquiry. They've defined it they haven't really defined it. They've said, how are we going to define it, and should we define it fairly narrowly? I think they've got a legitimate interest in opening up possibilities for some innovation and see what people will come up with. But they did not preclude themselves from acting upon anything that was a real end run of current obligations, if any, to provide just basic internet access.
Harold?
Yeah. This is where I get to say specialized services are a solution in search of a problem, that there's no sign that specialized services actually exist. No one can agree on a definition of specialized services. Why shouldn't the FCC just wait and see if an actual market in specialized services develops before they rush to make a rule? Blah, blah, blah. Link promised I could sing him after he was gone. But the issue here, to my mind, and this has been PK's position so far, has been that, to some degree, this is either a needless distraction or a Trojan horse. It's a needless distraction if we are just saying, look, there's nothing magic about IP. If you want to offer IPTV as a cable service, and it looks like an MVPD cable service, and you just happen to be offering it on the same wire using an IP technology, sell that as a cable service. You don't count it as part of my broadband service. You don't tell me that, I've got this much download capacity when it's really reserved for delivery of your television service. But, it's a problem. The act is solved. If, somebody wants to tell me there's a video game service where Xbox is going to offer with Comcast, a special, managed game service that's uniquely available to Comcast subscribers, and they're going to package it and do all sorts of wonderful value-added things to it, it's no different from any other value-add. The danger comes in, and where the Trojan horse element comes in, is where managed services simply becomes a rebranding of the kind of discriminatory pricing or quality of service assurance, or whatever it is you want to call it, that we've been actually arguing about for the last 5 or 6 years. And that all you have to do is sort of wave the magic wand and say, I'm not, doing exclusive tiering, I'm doing, managed service, and suddenly everything is fine again. So I think that, in some ways it's an easy problem, in some ways it raises a number of, concerns, just to make sure that it doesn't become an exception that would end up swallowing up the, quote, public internet, or the best efforts internet, or whatever phrase we're using to describe what we have now, and we move to an area where you get essentially a bundle of very carefully defined managed services.
Okay, next question.
And I was just wondering how in the real world that kind of a thing is enforced, particularly the last one, which is customers have a right to competition in the provision of services and application, et cetera.
Well, I think that the Waxman approach would be simply to have legislation, have a statute that says the FCC has the authority to enforce and it would be up to the FCC what rulemakings and what rules they would need to establish to enforce. I mean, because that's basically what the Comcast court took away, is the Title I theory of enforcing those consumer rights. But of course, as I think Harold pointed out, the Waxman draft also suggests that they would not have rulemaking authority. Is that right?
Well, I mean, this is where, you ask an excellent question, and, which is perversely the one thing that may get the statute through, a bill through, which is the high degree of ambiguity, which would be that there is tremendous risk from both sides.
Yeah.
The question, normally a very ambiguous statute, and the policy statement is an ambiguous statute, delegates enormous power to the agency to interpret. That's standard legislative. On the other hand, you can certainly make arguments that what Congress intended was just that the FCC do what it did before, which is very narrow. On the other hand, the FCC, in all of the things that it was doing before, explicitly reserved to itself the right to decide the bigger questions, going down. So you're back in very broad. On the other hand, and so on and so on. Again, it kind of boils down to I appreciate what the Waxman staff are trying to do, which is to, at the very least, provide the minimum level of certainty for people to be able to move off this issue and focus on the other elements of the National Broadband Plan by saying, let's just legislatively wind back the clock or reverse the Comcast decision to provide some clear authority on this issue. But the difficulty is that prior to Comcast, the authority was unclear on this issue. So moving us back to the world before Comcast has that difficulty of it would still be very unclear for the FCC when it tried to implement such a statute.
Other questions? Okay. One thing, we talked about the NOIs that keep on coming. At one point, I was curious about all of your thoughts on this. At one point, do you just have so much data that it just becomes impossible to find anything from it? I mean,
Now?
I think we passed that point months ago.
Well, in defense of my friends of mine who are staffers at the FCC, I mean, to be honest with you, I think a lot of and I say this as a former FCC staff attorney, I think one of the problems with this whole debate is that we've gone actually from substance to turning this into sort of a, who files the most email comments. So I think a large chunk of that record, to be honest with you, is just the FCC is supposed to make a decision based on the facts, the law, the economics, and the record before it. Having 30,000 emails going, I support net neutrality or I hate net neutrality. What are you going to do? Go to the court and go, see, it's the weight of the evidence, Your Honor. That's not dispositive. So, and I think the FCC is going to make some very critical decisions. So that's part of the problem.
other questions? I'll keep going, but wanted to make sure other people have the chance. Yes.
Yes. What is the interplay between with the policy statement do you think that there's any effect of the policy statement being referenced in the Recovery Act as a standard to be used as part of the broadband plan? The policy statement from 2005?
Well, I mean, what the commission has proposed in its open internet proceeding that it commenced fall of '09 was to codify the policy statement plus two things, the non-discrimination principle and the transparency, the disclosure of network practices and that. So, yeah, I think it is significant that the last time Congress spoke on this, in the Recovery Act, that, you know, that there was some reference to the policy statement rights, consumer rights.
Yeah, but look what happened with the Recovery Act. They put in that non-discrimination standard, and when it came to putting out the bids, all of the people who are the most efficient would be the most efficient recipients of those funds. People who already have trucks, people who already have networks, people who already have building systems. Not one of those existing carriers bid for that money.
And it was entirely because of that provision. And
I think you're going to.
There were thousands and thousands.
Well,
of
first of
bidders.
all, if that worked, you know, if that was the thing that kept companies that frankly don't need this money and had it go towards more innovative middle mile projects, then woohoo, from my opinion. We can debate whether BTOP was a good program or a bad program, or whether the money went to people who deserved it or didn't deserve it. You know, I'd be happy to take that debate at some point.
Did none of your members bid? Did none of them bid? Yours?
Ours
Your
did. Oh,
members?
yeah, no, we've got some people that bought last mile. Their problems have been elsewhere. They've done mostly BIP, the loan grants from RUS, and with all the uncertainty about universal service support for rural telephone companies, a number of rural telephone companies have turned down their BIP grants.
Yeah, but the question of how you look at this in terms of kind of the broader context, I think is, again, you know, number one, it also required interconnection, which the current, you know, formulation of the principles doesn't. You know, it clearly indicates that Congress thought when you were paying public money, you ought to have these, you know, broad goals embedded in your network. You know, so I can say, you know, Congress clearly liked it, and, you know, thought that at least when we were going to expend public money, we ought to encourage it as a policy. That might be relevant in a future USF debate about what sort of things, you know, if the USF is a limited fund, you know, should you give it to people who do better interconnection or something like that. But I think as a legal matter, it, you know, it doesn't really help to inform you know, the FCC's overall question about authority here. I think it's, you know, useful, but, you know, it's kind of only tangentially related.
Yeah, the rural carriers weren't too upset about the interconnection and non-discrimination requirements for filing for BIP and BTOP grants. That didn't throw people off. I think in some cases, the restrictions upon sale for about 24 years have caused a lot of family companies some heartburn. And just the overall reporting for what appears to be forever, and what the RUS is taking the position that fiber is about a 24 or 30 year useful life equipment, and therefore they want to regulate it for that long. We think that'll probably go away in a couple years, but you know, it's in the agreements for 24 or 30 years, so it's hard to tell clients that, well, they're not going to have to keep on doing this until their grandkids take over the company.
Other questions? Okay. Well, I'll ask a closing question for some predictions from you guys, and then you guys feel free to close with whatever remarks you have left. So, considering where we are in the legislative cycle, we're pretty much near October. Elections happen in November, and then, well, it's pretty much the end of the year. It looks more and more likely like this issue will be punted to 2011. What are your predictions, if you have any, of what the political landscape will look like then, and if that will how that will change the situation? Will it make things easier, or will it just make things that much harder?
I don't think that the changes that will come from this next election will make it easier or harder. It'll be the same complex, controversial issue that it always was. You know, the battle may be joined anew if the FCC acts before the next Congress comes in. There'll be folks in Congress that don't like whatever the FCC does, and so that may gin up a new push for legislation to counter or undo whatever the FCC does. But that's as far as I would go.
Yeah, in Congress, for many, many years, telecommunications has not been a hotly political issue between the parties. They've been able to work together on telecommunications legislation. We really hope that it stays that way. I'll be horribly disappointed if there's not a turnover in at least the House, but I don't think it's going to make it any more or less difficult that telecommunications legislation and internet legislation gets through.
I would say, one, what is sometimes difficult for people like us to accept is that we are not the center of the legislative universe. The issues that Congress and even the Commerce Committee deal with on a regular basis are regarded as far more pressing. That said, it is obviously easier for an FCC chairman if his own party controls the relevant committees. On the flip side, I'll point out Kevin Martin got on pretty well with a Democratic-controlled Congress on a number of issues, and towards the end of his tenure actually had a hell of a lot more problems with his own party over a number of the things that he wanted to get through. The FCC is an independent agency. It has a lot of scope if it's got a chairman with vision. And I think that at the end of the day, that's really the ultimate question is, what is Janikowski's vision and what is he willing to do in order to make it happen?
Yeah,
Anyone else?
I had long ago given up making prognostications because every day is a new and thrilling day in telecom. I mean, it's going to be interesting. I mean, the Republicans take the House. I mean, one scenario, this is just one of our pet conspiracy theories that we've just been sort of bandying about. I mean, depending, if this administration really wants to go forward with its net neutrality proposal, they could always do it and dare a Republican Congress to say, fine, pass a law, my guy's still sitting in 1600 Pennsylvania Avenue. Do you have the votes to overturn a veto? I don't know. I mean, there's lots of things. The other hand, maybe we can get some consensus and we can take a holistic approach and actually fix all the problems that we've all been talking about today. I don't know. What I do know is that this issue will continue, as we've all talked about, because it doesn't go away. It's a huge part of our society. It's a huge engine of our economy. These are complex, difficult issues with many, many cause and effects. And I think as long as we can keep being conscientious about these issues and think about what's the best way that consumers are better off, that the debate will move forward.
John, anything to add?
Economists already have a terrible reputation for making bad forecasts, so I'm going to avoid adding to that terrible reputation. Just simply say that I agree with essentially the sense of everybody here in their closing remarks that this is as much of a hotbed issue as this is for the people in this room. We've got a lot of issues to deal with in this country, and they're dynamic and evolving, and at some point there will be a window where telecom percolates up to the top of the pile, and it's not clear what will happen because we don't know when that's going to be. And at that time, I think as much fun as we're having debating these issues today and people discussing these issues today, there will be more focus at that moment.
On an associated question, read Richard Clarke's Cyber War if you want to get into something that's somewhat tangential to this, but if you want to get half scared to death as what some of the openness can lead to. Very interesting book.
Great. Well, please join me in.
Before we do, before we thank our panelists and our moderator, I just want to remind everyone Harold and Larry were saying, we could debate the broadband stimulus. And in fact, we will on October 19th. The very next Broadband Breakfast Club is evaluating the broadband stimulus, so please mark your calendars for that date. Also, just a reminder to please fill out your survey forms that are on your table and drop them on the table as you leave. And I'd like to ask for each of you to join me in thanking our sponsors, the U.S. Telecom Association, International Broadband Electric Communications, Inc., Telecommunications Industry Association, and the National Cable and Telecommunications Association, along with our great panel. Thank you very much. And Kim Hart, wonderful job. Thank you very much.